All right, it's 5:30. I'll call this meeting to order. Would you please join me in the pledge of the flag? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all for coming tonight. A reminder, our mission is to encourage everyone to see and be their personal best through successful learning experiences. Become your best. Item 4, adoption of agenda and consent agenda as the order of business with identification of items to be taken off the consent agenda for discussion or separate action.
I'd actually like to make a motion that we change the order and have the period of public participation before we review the policies, if possible. So I
Okay.
hereby move that we exchange items 8 and 9 on our agenda, just to reverse the order.
Okay, is there a second?
Second.
Is there any discussion? All in favor say yes? Yes? All right, thanks, Janelle. So now we need to consider approval of the consent agenda as adopted. Approve the minutes of, that change. We still have to approve the consent, no, that's,
Right, we still approve the consent agenda.
yeah, we still need a motion to approve the consent agenda then as adopted. So we made the change, but now we need to approve the consent agenda.
I move that we approve the consent agenda as amended.
Yep.
Second.
All in favor, say yes.
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 All right. Now we need to consider approval of consent agenda as adopted. Approve the minutes of June 18th, 2024, regular Board of Education meeting. Approve financial report for the period of July 1, 2023 through June 30th, 2024. And approve the bills for the period June 1, 2024 through June 30th, 2024 in the amount of $2,934,184.25.
So moved.
I'll second.
All in favor, say yes.
Yes.
Opposed?
Yes.
All right. Item 6, academic pillar of excellence. Consider adoption of the 2024-2025 academic standards. Dina?
If any questions, this is
What we
something we
dis-
do every year, and we haven't made any changes to our curriculum and the resources that we use.
Okay. So I need a motion.
Make a motion to accept the 24-25 academic standards.
Second.
All in favor, say yes.
Yes.
Yes. Opposed? Item B, consider approval of proposed revisions to 2023-2024 high school orange guide for the 2024-2025 school year. We discussed it in committee of the whole. Joe's not here.
Joe's not here, but Andy is.
Okay.
If anybody has any further questions.
Hearing no other questions, can we have a motion to approve?
So moved.
Second.
All in favor, say yes.
Yes. Yes.
Opposed? All right, item 7, Finance, Building, and Grounds. Consider and approve the 2024-2025 Community Eligibility Provision Program. Amy, we discussed this committee of the whole.
We did. Karen has a couple pieces of information that we were waiting for, so do you just want to fill them in on the reimbursement rate?
Yes, so last week we had some questions of what the reimbursement rate was going to be, and we were waiting for final approval from DPI. Both of those have come in on Friday. We were given final approval through DPI. Our percentage did meet the qualifications, and the reimbursement rate has been released. It did go up slightly, which is good news for all of us. And the only other consideration would be, because of that new pricing formula, which would be free for students, that we would have to make some slight adjustments to our adult meal pricing program based on a formula that they use. So our adult meal pricing could go up somewhere around 50 to 65 cents.
Okay. Any other questions about the program? We discussed it quite a bit in Committee of the Whole. Good news on the rate and good news that we qualify.
The rate went up. Can we discuss like by a percentage, or can we disclose what the rate is, or?
Yep, so, I can just give you from last year, like the cents that went up. So for the breakfast program, the breakfast reimbursement for paid meals went up by a penny. For free meals, it went up by 11 cents. And then we also get additional state aid, and the additional state aid went up almost 2 cents. So in total for breakfast, we're gonna get about 13-ish cents more for breakfast. For lunch, the paid meal pricing went up 3 cents, and for free meal reimbursement, that went up 19 cents. We also get an additional, it's about a penny in state lunch aid also for each additional meal at the state level.
In total, that's around 20.
3.
24 cents with some rounding.
All right. Any other questions?
And then how, does that make us feel a little more comfortable? What does that do to the totals?
Yeah, that takes us out of
Expected
that
total.
worst case scenario that we were
Okay.
talking about, so we're definitely in a more comfortable place. It still is going to depend on participation, on how much it shakes out each month, but we can keep an eye on that each month when we submit our reimbursement.
Yeah, my goal would be, if this is approved, to revisit it after the first year, to see how we did. If you'd like updates, maybe halfway through the year, we can do that, and then kind of just evaluate how it's going, if it's going the way that we thought, where we're landing, things like that. We won't know much else until we have, if it's approved and we have participation, well, then that's how we're gonna know if we can continue to do it.
So you think you would be able to have a mid-year kind of update tracking what we've had within the first handful of months?
Oh, sure, because we track everything per month, so, yeah.
And how does participation actually work? Is it just a student, or do they have to like register in advance, or is there anything like that? It's just whoever,
Show up, and as long as they meet the nutrition requirements, which most of the kids know, and it's classified as a reimbursable meal, we just count it, and then we turn in our numbers at the end of each month for a reimbursement claim.
okay,
And our percentage, Dan, since you asked about percentages too, so what we got approved for is 41.9% of our meals will be reimbursed at the free rate, and the other 59.1% will be reimbursed at the paid rate. Was our final percentage.
You advertise this out to families?
We will after
We will.
approval that, and when we start sending out messaging in August about
Yeah.
sneak peeks and things like that coming up, we'll also start sending out information at that time too.
okay. Any other questions? I need a motion to approve then.
Make a motion to approve the community eligibility provision program.
I'll second.
All in favor, say yes.
Yes.
Yes. Opposed? All right, thank you. Item B, consider gifts and corresponding budget adjustments. Scott, are you going to take that?
Yeah, I'll take that one. As you know, we are incredibly fortunate to have a very generous community, individuals, groups, et cetera, supporting our kids and our programs. We'd like the board to consider the following gifts and corresponding budget adjustments. I will read through them and then hope for that motion afterwards. A donation of $250 from Plymouth American Legion Auxiliary Unit 243 for the Plymouth High School Fitz Student Sharing and Career Closet. A donation of $4,616.37 from Riverview Activity Club for transportation to Bay Beach, Wisconsin Dells, Timber, Rattlers, Game, and the Milwaukee Zoo. A donation of $846.50 from Future Farmers of America for transportation to Fisher Farms and the Humane Society. A donation of $2,294.79 from Fairview PTO for transportation to Maywood, Wild Center, Nourish Farm, Manitowoc Farm Discovery, Camp Waikota, Camp Anakoji,
Anakiji.
Anakiji. I even practiced that one,
Yeah.
Katrina. Anakiji. I'm
Obviously not a local.
so disappointed in myself.
That's a good try, though.
That was not bad.
You know, anyways, and the Milwaukee Zoo. A donation of $2,386.46 from Horizon Path Program for transportation to Camp Waikota, Camp Anakiji.
Good job.
Yeah.
Thank you.
Good job.
Thank you.
Wow.
Hookworm Gardens, Nourish, Milwaukee Zoo, Wild Center, Maywood, Sheboygan Historical Museum, and Mulberry Lane. And finally, a donation of $1,992.33 from Parkview PTK for transportation to Camp Waikota, Manitowoc Farm Discovery, Milwaukee Museum, Nourish, Wild Center, Maywood, Above and Beyond Museum, Siberian Outpost, and Sheboygan Historical Museum.
Great. So I need a motion to accept these gifts and corresponding budget adjustments.
So moved.
I'll second.
All in favor, say yes.
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 Opposed? Thank you for all those contributions. And now we will move on to a change. So we're going to go to public participation and recognize anyone present who would like to address the board.
I have Tyler Alstrand.
All right? Tyler, welcome.
Yeah, welcome.
If you'd like to come forward, you can stand, right in this area, and,
I think you can all hear me.
yeah,
Thanks for opening this up. Congrats to the new soup. Haven't met you yet. My name's Tyler Alstrand. I've had two girls graduate from PHS. Some of you know them. All girls that played sports and made a positive impact in their sport. I currently have a freshman to be, so that'll be exciting. I'm not sure the public knows. I haven't been to the meetings for the last couple months. It's my bad, but I know the attorneys over here. But according to Education Week Analysis, which is a big website, pro education, as of today, the Biden administration's Title IX changes have had drawn at least 8 lawsuits. 26 states have signed on to the lawsuits, and the rule is on hold for 15 states. Currently, Wisconsin's not on the list, which is sad, in my opinion. But one of the lawsuits, Arkansas versus the U.S. Department of Education, which has Arkansas, Iowa, Missouri, Nebraska, North Dakota, and South Dakota all attached. And I agree exactly with their complaint argument in a 62-page lawsuit. The Biden administration's Title IX rule, unfortunately, would gut the very athletic opportunities that Title IX was designed to provide. It would destroy the privacy protections for women and girls enjoying the restrooms, the locker rooms, showers, overnight accommodations for school activities. It's also going to preempt numerous state laws. Okay, so you can't do half the stuff that they're proposing that it's okay for the girls to do or students to be able to have access to in school, you can't do in town. So why are we subjecting certain kids to these situations? It's also going to silence and threaten with investigation any coach, student, faculty member, or administrator who doesn't share the department's views. That's a violation of the U.S. Constitution, in my opinion. And it's going to deny federal funding for a great school district if we don't follow to a T these new changes. That's going to open, I don't know, I recommend that the district be cautious about the policy adoption and to pause until the rulings are finalized in all these lawsuits across the nation. These new proposed changes open the door to so much to future problems for our students, in my opinion. I simply ask the district to please protect girls, biological girls, and girls' sports and activities moving forward. Thanks.
Thank you, Tom.
You're welcome.
No other participants? All right. Well, with that, we'll move into item 8, which is policy. Consider and approve the Title IX policy 2264, compliance with new regulations and federal requirements. We have Assistant Principal Andy here to speak. I don't know if Ann's here as well. But we've also asked Tony Renning, the district attorney, to come in and give us just a little bit of background on this and where everything stands with Title IX, so we understand the recommendations of the policy change and what we'd be voting on tonight. So, Tony, you want to give us some background? And
Sure,
go ahead.
absolutely, Bob. Thank you.
Thank you.
So I just want to preface my comments by saying don't shoot the messenger tonight. I'm the attorney. I'm sharing with everybody what the law is or what the current status of the law. I'm not here to advocate on behalf of one side or the other. That's up to you as the elected officials to make that decision based upon the information. So you have to be well informed though to be able to make those decisions. And so that's where I'm coming at it from. This is obviously a very hot political potato, has been for some time. The Obama administration, I think, started with Title IX and modifications to the Title IX policies. And then when the Trump administration took over, all of those interpretations and guidance, all of that was rescinded, and there was new guidance and interpretation. And now with the Biden administration, all of that guidance and interpretation in turn was rescinded and has been reissued. And depending upon what happens in November or January, it's very possible that this will all be, a lot of work and a lot of time and effort put in on behalf of the schools for nothing, because it all might change again. So that's kind of where we're at. 2020, the district adopted a policy 2266, which is the non-discrimination policy here in the district, and that addressed Title IX, and specifically it addresses concerns with regards to complaints about harassment, sexual harassment, and also with regard to sexual assault. Again, the district adopted that policy 4 years ago, and now we're at the point, based upon the new regulations and the new interpretation and guidance, where the district has to take up the issue of the new policy. And as the public speaker had just shared, there are consequences if the school district doesn't adopt the new policies. The Office for Civil Rights, through the Department of Education, and then ultimately the Department of Justice, may take action to enforce or to try and take away federal funding to those school districts who do not comply with the new direction. But let's start out the big change. So what you're being asked to do tonight is to make some revisions to Board Policy 2266, which is the old board policy with respect to Title IX, and then to adopt Board Policy 2264, which would be the new board policy with respect to Title IX. Same issues. It's to address, for the most part, complaints with regard to sexual harassment and sexual assault brought by students, brought by staff. For those situations or those circumstances involving educational programs or activities where discrimination is alleged to be taking place. The difference between the two policies are really twofold. One is the definition of sex. Under the new policy or under the new guidance, the definition of sex has been broadened to include sexual stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. And, I think it's the sex orientation and gender identity, which has kind of been the lightning rod that's out there with respect to the broadened definition. The other part of the policy that's changed and is the kind of area of unknown and how it's going to have an impact, if it does have an impact, upon co-curricular activities, restrooms, those types of things, are the consequences tied into the policy itself. And that it can be basically boiled down to three things. First, no person shall, on the basis of sex, and that's that broadened definition of sex, be excluded from participation in or be denied the benefit of or otherwise be subjected to discrimination under any education program or activity. And then it provides that in limited circumstances in which Title IX permits differential treatment or separation on the basis of sex, so those cases where athletics, for example, where you would have male sports or female sports, Title IX or the educational institution must not carry out such differential treatment or separation in a manner that discriminates on the basis of sex by subjecting a person to more than de minimis harm. So that's the standard, de minimis harm. And then where this all comes together is the new regulations define what constitutes de minimis harm. So adopting a policy or engaging in a practice that prevents a person from participating in an education program or activity consistent with the person's gender identity subjects a person to more than de minimis harm on the basis of sex. So in essence, the new policy said that would constitute a violation of that particular policy. So that's where we're at with respect to the new policy as it compares to the old policy. The speaker made reference to 8 lawsuits that are out there. This is a political issue for all of these different lawsuits in all of these different states as well. So in Wisconsin, the Wisconsin Attorney General has not been authorized to bring a suit challenging the enforcement of Title IX, and that is why Wisconsin is not party to any of these federal lawsuits. For the most part, the federal courts have been restrained. Generally, what we've seen is a race, depending upon which side it is, to the Northern District of Texas, for example, and you get a district court judge down at the Northern District of Texas who enjoins the entire nation. So will enter an order that would preclude the entire nation from enforcing, for example, Title IX. That hasn't happened in this case. The various judges have been conservative in that they have only enjoined the states that are parties to the lawsuit. The exception to that being the case involving the state of Kansas, Kansas District Court, which is the last one. And there, a group brought a complaint to enforce prohibition or ask for an injunction prohibiting the Department of Education from enforcing the Title IX regulations. And the judge in Kansas issued an order that said the state of Kansas, the state of Alaska, the state of Utah, and the state of Wyoming were precluded from enforcing the Title IX regulations. But they went beyond this. They said that the plaintiff's school, so in this particular case, there was a plaintiff in Kansas, a school district in Kansas where the students had gone to school, where the families had gone to school, so they raised or had asked that the Title IX regulations be enjoined. The court said that particular school district in Kansas is also party to this. And then there were 2 other groups, schools attended by the members of Young America's Foundation or Female Athletes United. And then the last one was schools attended by children of the members of Moms for Liberty. So when the court issued this injunction, all of a sudden this one became a little bit broader as there are, these various groups. The Young America's Foundation or Female Athletes United and the Moms for Liberty exist outside of just Kansas, Alaska, Utah, and Wyoming. And so when the court issued the injunction, this was pointed out to the court. And so the court asked for the parties to provide input as to who exactly fell under those 2 groups or 2 categories. and they wanted that information by yesterday. And so the parties submitted a list of the schools that would fall underneath that. The court, I was just sharing with Scott as I was driving over, the court was making changes or entering the order as of late this afternoon. But the court has now entered the order, which again prohibits the Department of Education from implementing Title IX in those 4 states. Also with respect to the plaintiff school district, schools attended by members of the Young Americas Foundation or Female Athletes United, and then certain schools who have children who are members of the Moms of Liberty. And here in Wisconsin, there are approximately 25 school districts that are specifically precluded from adopting the Title IX regulations. I would say for the most part, most of those schools are in the Milwaukee area. There are a few Green Bay schools, Howard Suamico Bayport, Notre Dame Academy in Green Bay, St. Paul Lutheran Schools in Green Bay, Stevens Point School Districts, Superior School District, and yeah, again, the rest of them are all pretty much the Milwaukee area school district. So that this case, although it had the potential for being a lot broader and potentially enjoining other school districts from adopting the Title IX regulations, does not enjoin the Plymouth Joint School District from adopting the new Title IX regulations. So that's where we're at as of 5 o'clock this evening, as far as everything that the courts are doing, or the status of the Title IX policy in the courts. Regardless, I guess, again, there's a lot of dispute, a lot of question with respect to these Title IX regulations. For the most part, the intent behind the new policy, 2264, is to allow an avenue for investigation of and action related to complaints related to sexual harassment and sexual assault on the basis of sex, under the broader definition. I think we will have issues come up maybe down the road with respect to participation in co-curriculars, as well as use of facilities and those types of things. But for the most part, the focus of Board Policy 2264 is the complaint procedure and how do we address complaints to make sure that students are not being denied the opportunity to participate in educational programs or activities. I guess the other part of this is a lot of publicity, a lot of discussion about this new policy, but in the grand scheme of things, I'm not sure that the new policy adds a whole lot or makes a whole lot of difference. Under 118.13 Wisconsin statutes, school districts are precluded from discriminating against students on the basis of sex, and that sex includes gender identity and gender orientation. That's addressed by PI 9, so the Department of Public Instruction, if there's a complaint or a concern, would get involved anyway, would investigate and make a determination as to whether the district is unlawfully discriminating against students on the basis of sex, that broader definition. Here in Wisconsin, we have a case, Whitaker versus Kenosha Unified School District. For those of you, I think, maybe 2 years ago, this was kind of 2 or 3 years ago, this was the kind of hot case. It never made it with respect to the merits of the case, but the Seventh Circuit Court of Appeals, which is the federal circuit here that addresses Wisconsin, has essentially decided or has told us that it will decide the Wisconsin cases involving sex or interpreting sex under Title IX to be as broad as it is in the employment setting, where the Supreme Court has already extended the definition of sex to include gender identity and gender orientation under the Bostock case. So again, in Wisconsin, we've got the federal courts that are telling us where this is headed. And then the district has on its books already Board Policy 5517, which is its anti-harassment policy. And that anti-harassment policy provides a definition, or provides that the board will vigorously enforce its prohibition against harassment based on the traits of sex, and that includes gender status, a change of sex, or gender identity. So at least from the district's perspective, we've kind of adopted that broader definition of sex already. We've had that on the books in 5517. So as far as, this being a sweeping change, I'm not sure that the new Title IX policy is all that much of a sweeping change for the school district or for most of the school districts here in Wisconsin. Just a little bit with respect to the consequences. So the timeline for adopting this new policy is August 1st of 2024. They didn't leave schools a whole lot of time to do this. They talked about these changes coming for about 18 months, but by the time they finalized them and issued them in March or April, schools kind of had to scramble to get the policies in place. And so your policy provider, Neola, has provided the policy and the options that were reviewed by the district, by the policy committee. I've had an opportunity to review them and make sure that they're in compliance with the proposed law, as well as what the recommendations were by the policy group itself. But there are consequences if the school district doesn't adhere to this. First and foremost, as the speaker alluded to, the Department of Education, through the Office of Civil Rights, could exclude the district from federal funding, and that's certain parts of federal funding all the way through all federal funding. So they could take away any federal funding available to the district. I don't know, obviously if we don't have the policy in place or you take time to review this, they don't have the manpower to come in on August 2nd and do a review of every school district in the country and make sure that they've adopted a Title IX policy that's in compliance with the new regulations. But the issue is, it's not so much OCR doing that on its own. It's that if we have a complaint that arises or an issue that arises and we haven't adopted that policy, that the individual who's bringing that complaint is then going to go to the Office for Civil Rights, which is going to set in motion their investigation, or they're going to go to the Department of Public Instruction, which is going to set in motion their investigation under 118.13. We just went through this under the old Title IX policy with respect to one of the districts that the firm represents, the Rhinelander School District. They were a little slow in adopting the 2020 board policy, 2266. And as a result of that, there weren't any complaints, there weren't any issues. But when there was an issue that came to light, we didn't have that policy in place, and OCR became involved. And OCR didn't come in and say, we're going to cut your federal funding. They said, you've got an option, which is adopt that policy now and adhere to that policy. But on top of that, you're going to enter into this consent decree with us, which means you're going to take all these added steps and protections that we believe are appropriate. And the district has expended a significant amount of time, effort, and money trying to adhere to that consent decree. It is expensive. It's taking up a lot of time and effort for the district to do that, a lot more than simply having adopted that 2020 Board Policy 2266 if they had originally done it. The other threat was from OCR, not that, again, not a flat out, we're going to take away your federal funds, but if you don't want to enter into this consent decree, then we will turn this over to the Department of Justice for enforcement. And that's where, if the Department of Justice finds that you haven't adhered to the policies or the statutory criteria, then you are subject or potentially subject to losing federal funding. So there are, I can tell you, other districts that have been slow and maybe still have not adopted the 2020 policies, so Board Policy 2266. That's not my recommendation. They're gambling, and they're living right now by the grace of good luck, that they haven't had an issue or a concern come to light. Our advice as a firm, again, given the most recent decision coming out and guidance coming out of Kansas, there are other places or other litigation that's still a possibility. Again, none that Wisconsin is party to, and so it's unlikely that would have an impact on Wisconsin, but is to adopt Board Policy 2264 and revise Board Policy 2266 on or before August 1st so that you're in compliance. So it's kind of where we stand with respect to the law and what the potential consequences are. And with that, I'm happy to answer any questions that you as a board might have or administration.
Questions?
I have questions.
Sure.
Yeah, and I read through the 26 pages last night.
Right.
In reading through this, and I know there's a lot of fear of the government, and what are they trying to tuck in there and hide in there? Is there anything in there that, okay, if an issue or concern comes up with a student, can we pull in the parents and say, hi, do we want to let you know that your child is talking about this?
So there isn't anything in, that's been there's been litigation here in Wisconsin and concerns about that. Madison School District, there was also one down south, Kettle Moraine School District as well. That is not part of these specific regulations. So there is nothing in the regulations that say that, a school district cannot communicate with parents if they know that, a student has raised questions or is asked to be called by a different name or is, suggested that they're transitioning. So there's no violation of the law for the school to reach out to parents.
I guess in the expanded definition too, it talks about paternity concerns and issues of that nature. Is there anything, again, it could be just too many weird headlines and trying to read through it all, but there's some topics that maybe a school board then would be forced to help support, even like the Planned Parenthood connections and all that, through this topic.
So there is the option in your board policy with respect to, so 2264 does address that, but it gives the option. So if you have a Planned Parenthood program, then you can adopt that option, but it doesn't require, the rules or regulations do not require you to do that,
Okay.
so.
All right.
Other questions?
After you were here last time and spoke on this, there was a lot of discussion afterwards about how do we actually take care of it in here, because we want everybody to feel comfortable, not only the whatever 1% and the 99%. You have any suggestions, or do you know how other districts have taken care of that issue in the bathrooms, in the lockers, in the showers?
Yeah, so the law hasn't changed since the last time I was here. I mean, the district is still precluded from, requiring somebody who's transitioning. So if I'm a male, I'm transitioning to a female, I want to use the female locker rooms or the female restrooms. The district, by law, can't preclude me from doing that. So that hasn't changed. What I've seen, I haven't seen those issues so much. They're being addressed by the counselors, by the school administrators. So when those issues come up, they're having conversations with the student, with the family, with the other families that are involved. So again, they're working to provide options. And I guess that would be my recommendation, is that you continue to do that, because we've seen, I guess, less and less of the lawsuits about the locker rooms and the restrooms than we saw that initial surge. And I think the courts have been pretty consistent in how they've ruled. There is a decision out of the 11th Circuit, which may lead us to the Supreme Court ultimately weighing in on this. But even the way that the 11th Circuit got there is pretty contorted. So it would ask the Supreme Court to weigh in. But I'd say that the law, as I explained it last time, and as I just kind of explained it, is what it is. And so the administration, counselors are working with students. So if we have a female student in the example that I shared who's feeling uncomfortable, the administration is working with that female student to provide her with alternatives or to provide, barriers within the female locker room or within the female restroom, so that she, again, doesn't feel as uncomfortable. She's not going to be able to say, I'm not, you have to take that transgender student and move them somewhere else, but at least we're working through, or those options exist to help ease some of the uncomfortableness.
So you made reference earlier about the change in the political climate from Obama to Trump to Biden. And obviously, none of us have a crystal ball of what's going to happen in November.
Right.
So
2021, the Biden administration took over, and it took them, it took them some time to rescind and to modify Title IX again to do what they wanted to do. So the issue is, if we don't have any issues or any concerns that come up, it's not an issue. But if we don't adopt the policy as of August 1st and we have an issue pop up, the Office of Civil Rights is going to be looking for school districts to make an example of.
But if we already have our own policy of 5517 that is around the harassment piece, and from what I could read, the best that I could out of this document, it is primarily around the harassment and what to do with it and giving them tools, then why do we need to have another layer that's being forced upon us through the federal piece? We already have our coverage in 5517.
You have a general anti-harassment policy in 5517. 2264 and 2266 address Title IX specifically, and that's what the federal guidelines or guidance is requiring, that you have something that specifically addresses Title IX.
But if we already said that even in our policy of harassment is defined as sex, including gender identity, and sexual characteristics, then why do we need to?
Because so I'm using it from that example that you've already, to some extent, adopted that broader definition of sex in 5517. But what you haven't done in 5517 is adopted specific policies or procedures with respect to Title IX. And that's what the Title IX regulations say, is that you as a school district have to have specific policy or procedures addressing Title IX. And that's where 2264 and 2266 come in. They're specific to Title IX.
The back half of the policy is all about the policies and procedures. If this happens, then we'll do this. If this happens, then we'll do that. That's what I understand it is.
Correct. But yeah, in a lot of cases, 5517 and 2264 or 2266 are going to be a lot alike. They're both dealing with anti-harassment, right? But it's anti-harassment in 5517 that's broader. In 2266 and 2264, it's specifically related to sex. And it's
Broad definition of sex.
The broad definition of sex. And it's also the one that's being dictated by the rules. You have to have a policy that addresses specifically Title IX.
And I'm not sure if you answered what Janelle had asked or not, but with the late hour of this, and the different mandate that's coming across, is there, and the fact that this isn't an easy read, so thank you. Is there something hidden in there that they're trying to get away? Is there something in there that is going to catch us off guard because we did not understand the fine print or the language by which it was used in that way?
So I think, I alluded to the definition of de minimis in the regulations, and with that broad definition of sex. So the intent of this policy, at least the way it's proposed, is to address sexual assault and sexual harassment claims with regard to educational programs and activities. But at the outset, I explained, that's where we're at right now. I can see down the road with co-curriculars, with facility use, those types of things, where a student or a staff member could bring a claim under Board Policy 2264 or 2266, alleging that if we don't, allow a transgender student who's transitioning from male to female or has made the transition, participate in a female sport, that's denying that particular student the right to participate in a sport or an activity. And so we would have the obligation to investigate and come to a conclusion under that. So that's the door it potentially opens. That's not the intent of the black and white or black letter.
Sorry.
But philosophically, I think that's the intent, is to make it broader.
Because wasn't that the intent of 2266? Sorry, I got all these numbers jacked up. Wasn't that the original intent of 2266?
Well, same with regard to 2266, but it wasn't broad, the definition of sex wasn't broad enough, so that's why we get the modification.
Sorry, I didn't mean to be a one-sided conversation here.
No. And, I should share that there's some guidance or interpretation that OCR had issued, 6 to 9 months ago with respect to participation in co-curricular activities. So, feeding off of this, that's why I say philosophically, I think that's where they intend this, or potentially to go, when you're asking, is there something, something hidden out there? But, yeah, that's where I would say the next issue is going to be, if I had a crystal ball.
Are they encouraging or pushing this more so at all schools, not just public ones? I think private, it looks like you have to apply for an exemption, so they don't get a free pass.
Correct.
It's all schools.
Yeah, because there's, now they're threatening the federal funding or whatever federal funds are available to the private schools as well.
Okay.
Tony, I have a question. Does the WIAA play any role in this with sports?
Yes, but when they decide that they're finally going to weigh in and take a position.
That's the problem.
So, ultimately, they're going to have to come up with some rules as to eligibility and, who's eligible and who's not eligible to participate in sports. But they're not unlike the NCAA or, I think the only one that's really kind of out there and has taken a position is, kind of the Olympics and, those, the higher end. They have some pretty specific, rules that apply. The NCAA or the WIAA kind of doesn't want to take that issue on yet, so.
So if we could adjust, go ahead, Amy.
I was just going to say, if they do, when they do, does that supersede this, or which one, what if they're
Yeah,
different?
It's going to put us in a real tough position because you've got federal law out here that's going to say you can't deny somebody the opportunity to participate in this, but the WIAA saying that if you don't meet these certain requirements, that you have somebody who's ineligible, and if they're ineligible in participating, then you may lose games or lose the ability to participate altogether. So yeah, it's coming.
Thank you.
Yep. And I'm sure that's why the NCAA and the WIAA haven't really wanted to take on this issue.
But, under the current WIA policy, at least my understanding of it, I believe we'd be in direct conflict of their requirements currently around sexual orientation. They have very specific ways for a male transitioning to a female. As long as they fit this criteria, then they will allow it. And
Well,
I can bring that policy along. But if they're not following those guidelines from the WIA, we still, under this policy, would have to say, nope, sorry, WIA, this person has to play in girls' tennis.
Right, well, that's the argument, right? Under this policy or under the new Title IX regulations, is that it could constitute harassment or a denial of the ability to participate in an educational activity. So it's possible. The WIA, though, their rules, they have rules, but they're not specific enough, and they haven't been enforced. So they have to come out with something that specifically says this is the way we're going to do it moving forward, and they haven't essentially done that.
So, school districts in the area, are they adopting this or very similar?
So I went 50-50 last night. I had 2 school board meetings. I had one board that adopted the new policy and one that said, we're going to wait and see. So, it kind of blew up on all of us. These policies, we review them a lot, and, we work with the administration, work with the board, and share them. This is one of the few times that you get a call, and so we're all scrambling. We're all visiting school districts and school board meetings this week and next week as they're, grappling with this issue. So that's why I'm, not here to advocate one way or the other. I'm here to protect you from a legal perspective, to say that, the consequences, when you look at them, I get it from a legal standpoint. The consequences could be, pretty tough if we were forced to enter into a consent decree, or if we lost all of our federal funding. At the same time, I understand the philosophical and political positions that the boards are in too, so.
We're trying to make decisions based upon policies versus making decisions based upon science. That's what I'm confused by. And so I think, we see the political and we see the policies and we see the law, but yet we want to ignore the science of what it is.
Yeah, within those definitions. But those are the definitions we're given at this time. I don't disagree with you.
Oh, Tony, that's not at you, so please.
Yeah.
I hope you don't hear that.
Yeah, no,
I was just making a
So
statement.
ultimately, though, all of this is, what the intent, right? What's the intent? Is the intent, are they doing this because they want to create disruption in our programs? Or is the intent here that they want to protect the child, right? No matter what the child claims they are or anything else, the intent here is to protect the child and the discrimination against a child. And I think that's the intent. So there can be all these nefarious things, and we can think all day long on that, and we can think about the fact that we're not going to be collaborative with people, and we're not going to have conversations, and that this is all some sort of thing to just disrupt the fiber of our communities. Or we can look at this and say, look, we've been asked to take a look at our policies, make sure that we have policies that deal with discrimination, that deal with harm to an individual. And that's what I think the intent is. And sure, there's all kinds of participation things and everything else, and I have my own opinions on where that all is, but I don't think this was written to disrupt our sports teams or our extracurriculars or anything else. I don't think that was the intent. And I think as we move forward, we will need some sort of policy to move forward. And as I read this, other than the question of this one definition, the rest of this is quite clearly, seems to be a very reasonable policy on how we will address complaints and discrimination when a child feels threatened.
Yeah. It's not a whole lot different than the old policy, and it's, there are a few bugs from the old policy that were actually corrected in this policy as far as the grievance procedure, the complaint procedure. So, from that perspective, there's some good in this policy too. Not saying that overall, it's not, trying to protect students from discrimination isn't good, but when they sat down and looked at doing things, they've learned, so to speak, from the last 4 years, so.
Sure.
I feel like I've gotten all the details I need now to understand this better, because I assume I'm like everybody else here, I had no clue where 2264 came from. Even reading it, I wasn't sure exactly understand. I think the process is very simple.
Right.
I wasn't sure how broad it was. I think there's some terms, some definitions in here that I don't know how they match up with 2266. I didn't even know we had 2266. 5517 would be great to read as well, apparently. And I'm making a little light of this, but it's not, like, I need to know more. I'm not in a position here to vote for this at all, personally.
Yeah, and the only, from that perspective, I certainly understand that. I guess the caveat is just from the administration standpoint, not only are they trying to comply with the August 1st deadline, but now we've got handbooks and, student information and posting, getting stuff on the website for the start of the school year. So just from an administrative standpoint, you're kind of up against it, and that's nobody's fault except for Department of Education, thrusting this upon us with, a few months' notice, so.
If we post notice online, and I think that's what your recommendation last time you met with us, is to share like a general announcement to the public. Hi, just like to be aware that this may be, you may, like, your student may encounter a person of a different, all that. Is that notice, does it have to state like the 2024 version of Twiline or the 2020 version? Can it just be generic and just say?
That statement could just be generic.
Right.
Right.
So if we're working through and trying to get our head around this, could we wait 3 months until the elections all calm down and then,
Well, we do
but
have,
not repost a notice?
we do have an obligation, though, to post a notice with
Right.
regard to the complaint procedure. So,
Right.
we have that posted right now on our website. It's in I would assume it's in our student handbooks. Notice that 2266 is available as a complaint procedure,
Okay.
so, and that's required, so.
Right.
I guess the only thing I would say is that we just think about the committee of the whole meeting when Andy and I both spoke to you. We tried. This is pages of things, and I understand it's laden, with concerns. But we tried to just take a simple list and say, here's what we have. Here's the difference with this one. And I know that it's very understandable that you're focused on our children, but for those of us who have to administer here, policy was this, the new policy was this, and we tried to just keep it to here are where those differences were. So just to help with like those numbers, like that's kind of, that's what's made you a little bit here, is we had to do an update because of just the timing to the old one. But then this is the recommended new one by August 1st. So again, kind of to Bob's point, the intent, right, of what we were looking at, of wanting to accomplish by August 1st.
So the highlighted document that we received last week is labeled 2264. It's not 2266, but it does talk about 2266 at the beginning. So is this 2266 kind of rewritten and then color-coded to show delete, maintain? Was that how this was drafted?
Because at the time, when we had it, that's where we were at, working with Neola and Tony, right? You were working on the edits with us.
You got the newest one in the packet.
Yeah,
The one with-
clean copy.
Right, that was the one that Jean Bourne, our Neola representative, prepared for us.
I guess maybe my question more straightforward is the 2264, was it drafted off the basis of 2266? Or is it a completely new policy that will not read anything close to what 2264 is?
No, there's a lot of the same procedures, the grievance procedure and things like that are similar to 2266. But there are differences, sex being one of those, the definition of sex, the kind of caveats that I outlined at the very beginning as to what's de minimis and what's not. Then there are within the grievance procedure itself, things that, we have Title IX coordinators, and in the past it was regimented. For example, Title IX coordinators would serve as the investigator, but not then the decision maker, and not making a determination. So now those have been consolidated if the district so chooses. So there are changes to the actual policy or the grievance procedure.
And I agree, I think what you and Andy were able to share last week was very helpful. I think my concern is that is it that simple, or are there a lot of weeds that we are trying to make a decision on that don't want to put any of our students at risk within it? And so trying to get my arms, I can't say our, but my arms around it to understand it so that we are aware as much as we possibly can to what we're agreeing to and what we're putting you and the school district as well as our students, what we're putting them into of what could be next. And so, yes, I agree, Bob, every student does matter, and that's the intent of providing that. I'm concerned that there's what that line of harassment looks like, because it can go both ways.
Absolutely.
And so just how are we protecting?
But that's what this does, is create a procedure to evaluate that, and a group and a procedure that follows law and says this is the way we should do it. So
2266 has that same procedure.
it's changed now, it's updated. So it's been updated. So do you not want to update it, or what's the alternative?
Yeah, I need to know what 2266 said, and then compare it against where we're going with 2264.
That's what,
Where is that, I guess, is what I keep coming back to in a way.
I think everything scratched on here, right, is the 2266,
Yeah, I mean,
basically?
not to show the difference between 2266 and 2264. I mean, the highlights, when I went through, was, there were a lot of editing notes or drafting notes.
Right.
And, the administration and the board or the committees had the option to read through them and make decisions. And then, based on all of that, I just read through it to make sure that what we had selected or the options were consistent or in compliance with the law, so.
So our policy 2266 is the old policy that's in place right now, and then we'll add on this new policy on top of it.
Well, in essence, 2266 is going to go away on August 1st. If a harassment or an assault situation occurred prior to August 1st, it's possible that somebody could bring a complaint in October, and we would have to follow the procedure under the old policy. But at some point in time, we're going to be far enough down the road where 2266 is no longer going to be a board policy.
And Andy, you were involved in all of this, right, in this adjustment from 2266 to 2264? I mean, does it seem more reasonable, less reasonable?
I guess reasonableness is really subjective.
Is there more clarity or less clarity on how you handle the discrimination,
right.
how you?
I think the talking points Ann and I brought up, it's a broadened definition of what sex-based harassment is. So there is more overlap with 5517, as Erin mentioned. And then the other piece to it is that it includes the pregnancy, it includes more more measures for how are we going to pre-teach and prevent and help support children and staff from engaging in behaviors that could constitute sex-based harassment. So there's more proactive expectations. There's more expectations in the new policy with respect to documentation and how we document and how we keep track of, because it's going to get monitored and looked at more closely, I would imagine, by the Office of Civil Rights. I guess, from my perspective, when somebody I'm just going to say like a loose example. When somebody comes to my office and says, this has happened to me, or reports something that's concerning, how I would in general say this is, depending on what they're reporting, if it looks like something that might rise to the level of harassment based on anything that's protected under policy, I would say, first of all, be a good listener, right? And then I would say, so it sounds like what you're sharing with me is X, Y, and Z. They say, yep, that's what I'm saying. And then I would say, okay. I would say, you have a couple options here. I'm going to explain them to you, and then I'm going to invite parent guardian to be involved in this conversation as well, so that you can make an informed decision. And I would say this can be a school investigation, just like many other school investigations we would have. Or another option you have is to make this a formal complaint under whatever it would qualify under potentially. And then that initiates process XYZ. I will meet with you and parent guardian. We can talk through that process, give you a little think time so you can make an informed decision. Frequently parents and kids are like, well, I don't know what that means, formal complaint versus school investigation, right? And they're like, I don't know. And the policy is, I give them the whole policy, so then they're like, whoa, this is like 27 pages. So essentially it comes down to this, how I try to explain it, and Tony, correct me if I'm wrong, because I try to kind of use the words that you helped me to kind of use naturally, is that these policies and the process of formal complaints are put in place to protect students and staff from feeling like their supervisors or the adults aren't doing what they're supposed to do to take a complaint seriously. So it guarantees, in a way, the integrity of the process. It doesn't guarantee that the resolution turns out to be found to be discrimination, but it guarantees that there is a formalized process by which this complaint will be resolved and a recommendation will be made. And then there's a way to, within the process, grieve the process if you don't agree with its decision either way. So I would say in some cases, families and children will say, I do not want 27 pages. Mr. Novak, will you please just investigate this and work through it that way? And in other cases, they will say, no, I appreciate the offer, and I always say I take no offense to whichever one you choose, and they may wish it to be a formal process.
And often, we work on this together, so if Andy is doing that explanation, I'm the one taking notes in the room. And when we say that we, share so we're either going to share the old policy, or we're going to share the new policy, and we do what it says, and if we have any questions, we call our legal counsel. And because we want to make sure we do it to the best of our ability correctly, to respect that this has been asked of us or questioned, we try to be very thoughtful about that process. So in regard to new or old, I think this one certainly does, the new one, if you would, vote or in that way tonight. I do think it asks of us to be much more proactive with our training of others and making other people aware. And being proactive if you hear a rumor or, just this idea that we don't want to discriminate, so we want to have a culture where people feel they can access what they need and want to access. So it's that idea that we have to also plan ahead to do that training, right? And the training means we have to teach from this, whichever one you approve. But the standard, I think, is higher with what they would like in place by August 1st. I mean, is that fair to say, Tony?
Yeah,
Yes.
I would agree.
Did board policy, this is a little bit off subject, but not too far, so regarding board policy 2266, did it have or already have a section around breastfeeding or conditions around breastfeeding? Or was that just a whole new term that was put into 2264?
2264 addresses pregnancy and related conditions now, so it was incorporated as part of that.
So it wasn't in 2266 at all?
No.
Correct.
No, okay. So our policy with that is kind of, right now, it's just an unwritten rule. If someone's pregnant, there's special situations for feeding and things like that.
There's a state law that we have to adhere to with respect to that already, so.
Okay, so 2264 isn't really helping us a whole lot there. I mean, it provides some context to that, but.
Well, again, it provides another avenue that if we're not providing that opportunity under the law, then it's an avenue to grieve that or to, bring those who need to know into the know so that something can be done about that.
All right. Other questions? Hearing none, I'll entertain a motion to adopt the 2264 policy.
I think what I'm struggling with right now, Bob, is having, if we could have had all this information sooner. Like the definition from Tony and having a greater understanding of what it is, and again, it's not to disrespect Ann or Andy in it, because what they shared was great, but it just seems a little bit, I don't know, backs up against the wall, in my opinion, that's all. So I just want to state that.
So I guess, as a point of order, someone can make a motion, you can make a motion to table it, but we have to consider those consequences of tabling it, but we probably should have a motion in a second, and then we can have more discussion, and then we can vote. But
I make a motion that we adopt policy 2264.
is there a second?
Can we discuss then, since
Well-
there's not a second?
I'll second it, because I'd like to have the discussion.
Yeah,
So,
for me, I totally agree with you that it puts it, back against the wall. But to be able to not get into legal trouble, that's why I feel like we're almost forced to adopt it and approve it so that we don't have trouble down the road. Whereas we may not, but if we would, I think then this would be, protection on us. Do I, I just, really hope that, and I know that the staff has done wonders, with those that have these, trying to work through it with the students, with the families, and, you'd be between a rock and a hard place, because you want both children's to feel safe and secure, and it's hard to do in this situation, I feel. But I appreciate the effort that our staff goes to work through them efforts. The only reason I brought this motion to the floor is because I feel that it's a protection for us as a district. And down the road, if we want, we can unadopt it, correct?
Well, you could always change policy later on,
Yeah.
right? I'll chime in as well. I understand what you're saying about timeline. We're given this timeline. We are going to handle the challenges of gender, of all of these things. We're going to handle them the way this district normally has, which with a lot of compassion and a lot of thoughtfulness with everyone involved, right? It's not like people are lining up to challenge all of these conventions. There are a few individuals out there that will challenge us along the way. We should have the very best training. We should have the very best policies in place that we can have these discussions, and we can have the discussions without discrimination. That's what we should have in place. If Neola and our attorney and our staff members are bringing forward, this is the best policy, given the climate that we have today, and they're suggesting this is what we ought to adopt as that policy, then it's my feeling we should adopt that policy. I'm not sure what changes by tabling it, by putting it off. I'm not going to rewrite it myself, that I can tell you. And in the long run, as Sally said, if this is wheels off and we want to put ourselves into a position where somebody's going to go to a Supreme Court, Tony, we can make those decisions and vote accordingly at that point. But as I read this, and again, my head hurts from reading it several times over, the process and procedures outlined in here seem like good due diligence to me. I would want that as an employer. This is how I'd want people to behave and bring up discrimination, and how my organization would then address those things. I don't think there's anything there. It is just simply this one definition within there that sets everyone off. But this policy doesn't mean, if we adopt this policy, it does not mean anything more than we've adopted a policy that understands discrimination in a broader sense that we've already outlined in other areas, right? So it doesn't change that, and it doesn't mean that all of a sudden, anything changes within our organization, other than when discrimination occurs, when a complaint of discrimination occurs, we are going to handle it with the very best policy that we were given at the time, and that's what we're going to use. So my vote will be yes.
So, is there anything in the changes that deal with, the orientation or the gender issues? Is that, if we don't follow the law and something happens and we lose our funding,
Right.
where are we then? Like Bob said, that doesn't mean that, we're going to openly invite, any of this controversy. We deal with things on a case-by-case basis. So, the outline, definitely, it's good to have policy in place that, I looked it over too, and, I personally can't see, issues with it. I think that it's always good to have policy in place that outlines procedurally how to take care of situations that arise. And that's what was kind of read to me. And if it does include some of the new topics like the pregnancy and the breastfeeding and all that, then, that probably should be something that we're addressing as well, so I guess my stance would be to adopt it, and, politically, who knows? It might not be here, which personally, I would hope this would go away anyway.
I guess
where I'm
what
at.
I'm struggling with is just, we have layers of policy already, but now those are inadequate because we need to have more layers of policy. We can always offer training. We can always get better at training in the ways, but now we need a policy to give us permission to do training. So it seems like there's just this web, and then us needing to be able to understand how that web works, and then have our conversation to then make a decision around it. And so that's what, I'm just gently pushing back upon that process. That's all I'm trying to just share of, we have these different things, we can choose to do training, but yet we need to have a policy accepted in 2 weeks to make sure that we get the federal funding that we should get if we agree with the policy or not. So that's where, I'm just stating where I'm at with the struggle of it. That's it, period, full stop.
And I think that, when you talk about, it's politically driven. And, you have an administration that is up for grabs at the end of this year, and the administrations
Change.
They change, but they also try to get as much stuff done and passed and, before the end of the term. So, maybe that's why the push.
Absolutely, and
Politically
if
driven.
it is or if it isn't, I think it's just hard that we're strapped in Plymouth,
Forced,
Wisconsin,
right.
based upon
Yeah.
the policies that need to be pushed from the federal government. And that's just the reality of it. So we're trying to make decisions that are, they don't know who we are. We know who they are, and we have to make those decisions for our students, for our faculty, and for our families that are here. And so that's why I'm just being able to say, hey, this is, I know we want it to be easy, but it's not, in my opinion. So,
No,
that's all.
I don't think it's easy. I just think this is the reality, right, that we live in today. And I think the long run is somehow we want to see discrimination go away.
100%.
Right? Somehow we want to see that. And people have different ways of approaching it and how you speak to it and everything else. This is a policy that's thrown at us, and there's a lot that's outlined in here that just seem very reasonable to me. I mean, it just seems like, well, this seems like good discipline. And do we need policies thrown at us to be good people? No. Right? We don't. But the reality is, we have these policies put before us. So do good people say, yeah, no, I don't want to adopt the policy out of some principle of no one's going to tell me what to do? Or do you just say, you know what, we're good people, and we're going to do the right thing always? And if we have to adopt this policy, we adopt the policy, but we still need to do what we will always do that's right. And I think we're good people, and we're going to do what's right. It seems odd that we have a policy to force us to do that, but on the same token, this policy isn't forcing us to do anything other than be good people. So is it really that hard to say, let's adopt it and move on?
The part that usually gets the pushback with gender issues, we already have that.
Right.
So if that's a concern in adopting this, we've already got it in 5517. We're not adding that and inviting that.
I'm just asking for time to understand the difference between 2266 and 64. Like, I guess one question for me is still, does 66 include language around The term applies to activities that occur on school grounds or on other property owned or occupied by the board. Does it include extracurriculars? Does it include athletics? Is that a yes?
Both of them, yes.
Okay. So 2266 already has the athletic piece.
Yeah, it would be an educational activity or program, so under both policies.
Okay. And then, just for my benefit, and if I ever get asked this, has a Wisconsin public school ever been, of course, I'm sure they've been sued by a civil law firm under discriminatory law. Have they ever actually been docked or been deducted federal funds because of their policies?
So, not that I'm aware of, because I gave you the example of Rhinelander. What ends up happening is they don't push it to have Department of Justice come in and enforce it. They enter into the consent decree. So they agree to a settlement agreement in essence. So it settles on the steps of the courthouse before it comes to that.
All right. Do we call the question? Do we want to do roll call? I don't know. Or just voice vote? Sally? So call the question. We had a motion and a second to adopt 2264 non-discriminatory.
Right, yep.
Okay.
Dan?
No.
Tony?
Yes.
Bob?
Yes?
Sally, yes. Aaron?
Yes.
Janelle?
I don't like the timing, but I'm free. Probably just have to adopt policy.
Okay, thank you.
Okay. Thank you.
Tony,
Yep.
thank you very much. Please feel free to,
Yeah.
Okay.
yeah.
Thank you so much.
You're welcome. Good night, everyone.
Thank you. Good night. Okay. Well, that was a lot. Let's quickly go through the rest of our agenda. Board liaison reports, Sally?
Yes, Community Ed, let's do something fun. So Community Ed will be showing a movie July 31st. It is a free movie, but you must call the Community Ed office to let them know that you plan on coming, because if nobody calls, then they will not be showing it. It is The Boys in the Boat movie. There will be pickleball Mondays and Wednesdays from July 22nd through August 14th at Parkview from 5:30 to 7. If you want to learn how to make ahead meals, freezer meals, there's a workshop. You will make 4 meals to feed anywhere from 4 to 6 people, and this will be July 24th on a Wednesday. Introduction to watercoloring painting, it is ages 14 and up. That will be through August 1st. And then landscaping to draw birds and bees and help the environment. This is a free workshop. It is August 8th. And how to plan your meals when you're on a busy schedule, so you don't grab fast food restaurants. And this is going to be Wednesday, August 14th. That's it.
Thank you, Sally. Foundation, Janelle?
The Education Foundation and the group did not meet this month. They had the month off, but a subset of the group, the fundraising team, has kind of met last week and is brainstorming on possible big fundraising pieces. And they're also looking for ideas on what could be the capital reason why we want to have a fundraiser. So if there's something that, again, in the, I forgot what you call it, the other topics, building and grounds or something, other issues and topics or fundraising concerns that we could focus as our agenda for the fundraising, that would be good to know.
Cool.
And
cool.
reminder, use the Plymouth Pride pump to fill your gas tank, and go to Walmart and round up for the Plymouth
So
Education
are
Foundation.
they planning a fundraiser this year then? Or
It would,
it's every
we're
other
thinking,
year?
rather than having it in October, we're thinking of pushing it ahead to spring.
Okay.
Rather than getting caught up in all the fall sports.
Yeah, that's a good idea.
Okay.
Thank you, Janelle.
You're welcome.
Family, Kathy's not here, so no report for family resource. Personnel. Scott.
Personnel. I'd like to take this in two parts, essentially. We're seeking approval for the contracts in A and B, and I'll read those first. The board will consider the approval of a 100% contract for Stephanie Harris to be a special education teacher at Riverview Middle School, beginning with the 24-25 school year. Stephanie received her bachelor's degree from Concordia University, and this will be Stephanie's first year of teaching. Second, the board will consider the approval of a 100% contract for Dina Mills to be a special education teacher at Riverview Middle School, beginning with the 2024-2025 school year. Dina received her bachelor's degree from the University of Wisconsin-Oshkosh and her master's from Lakeland College. This will be Dina's 31st year of teaching.
Okay, we need a motion to approve the contracts.
Make a motion, we accept the two contracts.
Second?
I'll second.
All in favor, say yes.
Yes.
Yes. Opposed? All right.
All right, thank you. C and D, reference to resignations. The board will consider the resignation of Gina Rortvet, school nurse for Plymouth School District, effective at the end of the 2023-2024 school year. Gina has been with the district for 4 years. The board will consider the resignation of Kristen Vogel, special education teacher at Horizon Elementary School. Kristen has been with the district for 2 years.
Okay, need a motion to accept the resignations.
So moved.
Second.
All in favor, say yes.
Yes.
Opposed?
Thank you. And letter E, again, this does not need approval, informational, but Haley Barber, special education aide at Horizon Elementary School, has submitted her resignation. Haley has been with the district for 4 years. Thank you.
Great. Nothing for 12. Item 13, President's Report. I'll make it brief. I sent everyone on the board homework. I'm not sure if you saw it or not, but it is to explore just our, kind of revisit our values, our pillars, and have an open discussion about those with Scott and his team at our next committee of the whole. I think it'll be a great exercise for us all to reacquaint ourselves with each other, with some of the values, and also let Scott get to know us. So it'll be a good exercise. Please spend a little bit of time with it. I tried to make it as easy as possible. So, and that's all I have. Superintendent.
All right, July.
And welcome.
Thank you, thank you. I appreciate you having me. July obviously is a slow month as far as student accomplishments and things like that, but we've got two. First of all, our German trip concluded June 21st. And if you'll bear with me, Laura Cable did provide about a nice paragraph, just a synopsis of the trip that I think would be great for all of us to hear. 15 students and 3 teachers, Jessica Barrington, Laura Cable, and Sandy Nicholson, traveled to Carbon, Germany from June 6th through the 21st to meet with host students and learn about German culture. Started by Sandy Nicholson in 2008-2009, this two-way host school exchange has been taking place every 2 years, with 15 to 20 students traveling to and from Germany. Trips are planned by Sandy Nicholson and Jessica Barrington, which helps to keep costs more affordable for students. The benefit of having this well-established partnership is the long-term relationships they have created over the years. The friendships with colleagues in Carbon also help with new relationships for the kids and the families as well. The teachers commented that they loved seeing the students step outside of their comfort zone in so many ways. They were willing to try new things and did not hesitate to help out others when needed. They enjoyed learning about the school system in Germany and shared presentations in over 30 classes about life in Plymouth, Wisconsin. Presentation topics were daily life at PHS, school sports culture, common laws, and stereotypes. After their homestay with families, students visited Berlin. During their stay, they explored many important monuments. The teachers were very impressed with the students' interest in exploring culture and their respect for history. Overall, it was an incredible trip, and the teachers know that these students will forever carry these experiences into their future lives. Even though the German language program has ended, the school host opportunity is still available for all language students, and teachers look forward to it continuing for a long time. So again, a great experience for our kids. And nice to hear back from Laura and the crew.
It's
great.
I just want to say publicly thank you to Sandy Nicholson because she volunteered a ton of her time this past year to work with the students who were still in the German program. But the German program moved into facilitated studies. So she volunteered her time on a regular basis to work with those kids and help them still build their language.
It's fantastic.
Thanks, Dan.
Thank you.
Second celebration, Max Holly, who just graduated from Plymouth. Maybe you saw, but he's been invited to participate with the Wisconsin Singers at Wisconsin-Madison. So a huge celebration. Congratulations to him. We wish him well, and I believe February 14th is when they're coming back to perform here. So Valentine's Day, here we come.
There you go.
That's it as far as student staff accomplishments. As far as district update, just a few things. First of all, summer school is ending this Thursday. I had an opportunity to pop over at Parkview and Riverview and just chat a little bit with staff and students and kind of fill my own bucket a little bit. Great things happening well beyond the regular school year, so thanks to all the staff involved with that. District leadership team. Today was day one of a 2-day retreat. Tomorrow is day 2. We're in Port Washington, talking a lot about leadership, talking about employee engagement, goal setting, all kinds of really relevant things. The other byproduct of it is there are 250 other individuals that are participating in this, the majority from the public school area, but there are also private sector individuals as well. So yes, we get to hang around together quite a bit, but we also break up into groups that are deliberately not one another so that we're forced out of our comfort zone and meeting other people. So day one was great. Some of us came back early. The others stayed until the end, and tomorrow morning we'll hit it early again. And then lastly, this is not going to be about me typically, but it is my 3rd week, and I'm sure people are curious. I'm getting the question quite a bit. How are things going? You know, the word affirming really comes to mind because the people here are phenomenal. Their knowledge and expertise, fantastic. Their willingness to help and make the new guy feel welcome is truly amazing. So been very busy as far as meeting one-on-one with other administrators, talking about the strengths assessment that we did that we'll be doing with the board as well. Talking about their schools, their needs, things of that nature. So getting a lay of the land a little bit. And then Katrina has done a great job making sure my calendar is nice and chock full with one-on-one meetings with people from throughout the community. So last week was a super busy week. This week, a few more of those meetings. So really great introductory meetings. And the focus of all of them has been, yes, introduction, but then also building upon great partnerships that already exist. How can we strengthen them? How can we work together for the kids and families of Plymouth? So the last thing I'll say is to the board, thank you. You know, the conversation that you just had, none of you certainly took lightly, and I know it was weighing on you, but the dialogue and the fact that you wanted all the information that you could have, understand completely the timelines and things like that, trust me, we understand that. But the fact that you engaged in that dialogue and, you know, for the duration that you did and with the intensity that you did, I thank you for that. Okay. That's it.
Thank you. All right. With that, I need a motion to adjourn.